Good afternoon. We're going to do the roll call initially alphabetically, and then once a chair is selected, then we'll change it. Meeting's being called to order at 2:03. Board members Abkarian?
Here.
Lansifin?
Microphones, please.
Oh, yeah, I'm sorry. Lansifin?
Here.
Nakasone?
Here.
Ochoa?
Here.
Raggio?
Here.
Sheehan?
Here.
Steger?
Here.
At item 1A is introduction of board members and staff.
Good afternoon, members of the board. My name is Hassan Hagani. I'm the Director of Community Development for the City of Glendale. Today's staff presentation will be done mostly by Elena Bobolyan, who's sitting there. Elena is the Senior Executive Analyst with the Department of Community Development, and she is the person most familiar with all of the list of the issues that you'll be dealing with. And supporting Elena will be Jillian Van Meiden, who is counsel to the Community Development Department, as well as Mr. Mike Garcia, who is the City Attorney in the City of Glendale, Peter Zobak, who is the Deputy Director for Housing, as well as Mr. Bob Elliott, who is the Director of Finance for the City of Glendale. With that, I'm going to hand it to everybody else to continue the program. Thank you.
The board members are as follows: Albert Abkarian, Attorney at Law, Albert Abkarian and Associates; Philip Lansifin, Chief Assistant Director of Community Development, City of Glendale; Ron Nakasone, Executive Vice President, Administrative Services, Glendale Community College; Scott Ochoa, City Manager of the City of Glendale; Carl Raggio, former Mayor of the City of Glendale; Richard Dick Sheehan, Superintendent of Schools, Glendale Unified School District; and Brian Stigger, Director of Los Angeles County Consumer Affairs. At 1B is the oath of office to the board members, and that's already been administered by the city clerk. And at 1C, we have selection of the chair and the vice chair. The clerk will now entertain nominations for chair.
Mr. Clerk, I nominate Carl Raggio as chair.
I second.
Are there any further nominations for the office of chair? Okay, hearing none. We'll just take a roll call and either aye or nay. Board members Abkarian?
Yeah.
Lansifin?
Aye.
Nakasone?
Aye.
Ochoa?
Aye.
Raggio?
Aye.
Sheehan?
Aye.
Steger?
Aye.
It's Steger, isn't it?
Steger.
It's Steger? Okay, I'm sorry. Thank you for correcting.
We change places.
Okay, and now we declare Board Member Raggio the duly appointed chair of the Oversight Board. Yeah.
Thank you. And thank all of you.
And then the next business is the selection of a vice chair. May we have nominations for the vice chair?
Mr. Clerk, I'd like to nominate Mr. Phil Lansifin as vice chair.
Are there any additional nominations for vice chair?
Second the nomination.
Board members Abkarian?
Yes.
Lansifin?
Aye.
Nakasone?
Aye.
Ochoa?
Aye.
Raggio?
Yes.
Sheehan?
Aye.
And Steger?
Aye.
I now declare Board Member Lansifin as the duly appointed Vice Chair of the Oversight Board. At item 1D is the report of the Successor Agency Clerk. The agenda for the May 3rd, 2012 regular meeting of the Glendale Oversight Board was posted on Monday, April 30th, 2012 on the bulletin board outside City Hall. There are no minutes of approval. At 3 is informational items, and at 3A is presentation of an overview of the former Glendale Redevelopment Agency and Glendale Successor Agency projects and programs.
Chair. I was wondering if by any chance we can move item number 5, the oral communication, instead of the information. Public could actually speak. I'll wait until the entire program.
Is that in accord with proceedings? This is our first one, and normally, as the City Council does it, oral communications are events and disclosures with respect to the first part, and then followed by the summary of they can speak to any subject. Are we confined to listening to those particular items that relate in particular to what we do here as an oversight committee? And with that, I would say yes, we can have oral communications because we don't have any idea how long this is going to be. Is there anyone in the audience who cares to speak at this time?
I'm going to ask Ms. Van Meiden to give opinion for board consideration.
Jillian Van Meiden, City of Glendale, Counsel to the Successor Agency, Community Development Department. By way of introduction, I want to make it clear that I'm not here to provide legal advice to the Oversight Board. In fact, as part of your agenda, we are recommending that you authorize a Successor Agency to go out to an RFP to obtain separate legal counsel because of the inherent conflicts of interest between the board's interests and the successor agency's interest. However, for purposes of procedure, and as the procedure is typically held with regard to city council meetings, oral communications can be placed anywhere on the agenda, and it's for purposes of discussing or hearing information from the public concerning matters that are not on the agenda. However, for purposes of those items that are on the agenda, the public input can be entertained by the board members, and they can be given, the members of the public who wish to speak on those agendized items can be given a certain amount of time, usually somewhere between 3 to 5 minutes per person to speak on those particular agenda items. If that's the way the board wishes to conduct its meetings, it certainly can be included within their procedures.
Thank you.
I'm available to answer questions.
Is there anyone in the audience who cares to address the board at this time? If not, oral communications are closed. We go on to the next item, and that's the informational items and presentation at A, correct?
Good afternoon.
No, it's not.
Okay. Good afternoon, board members. For 3A, presentation of an overview of the former agencies and current successor agency projects and programs. If you could please advance to slide. Oh, okay. This is a repeat of the board members as introduced by Michael Dunn. The successor agency staff as support to the oversight board are listed on this slide. Additional staff that will be providing support to the oversight board and successor agency are also listed on this slide. This slide includes some terminology that we will be using going forward. Most of these new terms are called for in AB X126, which is the Dissolution Act. Just real quickly, if any references to HSC will be the California Health and Safety Code. Oversight Board, we listed as OB. GSA or SA are reference to Glendale Successor Agency or the Successor Agency in general. GRA is the former Glendale Redevelopment Agency that existed prior to February 1st, 2012. RDA is a general term used for all redevelopment agencies throughout California. EOPS is the Enforceable Obligation Payment Schedule, and ROPS is the Recognized Obligation Payment Schedule. As we go into those items, you will learn the differences between those two very important schedules. RPTTF is the Redevelopment Property Tax Trust Fund administered by the County of Los Angeles. The RORF is the Redevelopment Obligation Retirement Fund, and DOF is the State of California Department of Finance, and SCO is the State Controller's Office, California State Controller's Office. Selection of chair and vice chair, we already completed those items. This is an overview of the agenda items for today's consideration. We'll move on to item number 3A. An overview of the former GRA and GSA projects. This is a list of the main projects the agency was working on. If the board desires, we do have a PowerPoint that has pictures and short descriptions of each of the projects, which we handed out in the individual briefings with the board members. If it's the board's desire, we can go through that PowerPoint, or we can just take any questions on any of the projects.
What's the pleasure of the board? Continue as we are?
Mr. Chair, I didn't get a chance to get a copy of that documentation, so I can read it at my own leisure.
All right.
Okay, then we will move on to item 3B, background on AB 26 and an update on pending legislation. For this part of the presentation, I will move it to Jillian Van Meiden. This is the next.
Thank you, members of the Oversight Board. I will move through this very quickly, as I'm sure some of you have already had quite a bit of background and training on some of the components of this. I think I need the quick copy. Redevelopment has had a long history within the state of California, and this is just a very brief overview. You can read the PowerPoint as well as I can present the PowerPoint, but the Community Redevelopment Act was adopted in 1945, but the tax increment component of the funding for redevelopment didn't become codified until the Community Redevelopment Law was adopted in 51. And then there were a series of subsequent amendments starting in 52, which further refined and restricted the use of tax increment, the reporting requirements, the urbanized component of redevelopment. But really one of the significant turning points for the use of property taxes for urban renewal, as it was originally known, was in 1978 with the passage of Prop 13, which significantly reduced taxing revenues to local entities and disallowed general obligation bonds on the general fund. So this really increased the need for a form of financing, and that's when redevelopment agencies sprang into action under the auspices of the Community Redevelopment Law. And then stepping forward, just preceding the adoption of AB 26, and back in 2011, there was about $5 billion in tax increment from around the state that was being used to fund redevelopment activities. But as we know, based on the budget problems stemming within the state and the state's obligation under Prop 98 to devote 39% of its annual fund for education purposes, there have been a number of backfill mechanisms, including the ERAF, the Educational Revenue Augmentation. I always want to say enhancement, thank you, Augmentation Fund, and then the Supplemental Education Revenue Augmentation shifts to backfill the state's obligation for education purposes. There were certain shifts made back in 2008 and again in 2009. The 2009 shift was challenged, and that challenge was upheld in 2010. Is currently on appeal. Just so that you may or may not be aware that the ERAF and the CRAF obligations still exist despite the dissolution of redevelopment under AB 1X26. Which added the Dissolution Act to the California Health and Safety Code. It did not repeal all of the Community Redevelopment Law, however. It was just those components of the law pertaining to the use of tax increment financing. And as we know, that was upheld late last year by the California Supreme Court, and its companion piece of legislation, AB 27, was found to be unconstitutional. Therefore, as we know, redevelopment agencies were suspended as of February 1st. So, after the agencies powers were suspended, they were not able to issue any new debt or make any new contracts or amend contracts, amend or commence any new plans. There were only certain actions that were authorized during that suspension period, and they're listed there with certain enforceable obligations that we defined obligations that we were able to pay. We had to preserve the assets that were in place. And we did decide to become the successor agency. We've prepared the ROPS and the EOPS, and we did elect to confirm our existing housing authority as the housing successor pursuant to the law. The successor agency has particular duties which are listed here. They are in 34.177 of the Health and Safety Code under AB 1X126. Those obligations are ones that are under the purview of this oversight board, and those include, as listed here, the payment of the enforceable obligations that are listed on the ROPS that you will be reviewing today. So the definition of enforceable obligation is a very important component to your understanding of what your role here as an oversight board will be in terms of the approval of those ROPS to move this process forward. And again, as assigned and directed by the Oversight Board, the successor agency will be required to wind down activities, to dispose of assets, is unable to accelerate or prepay debts, and is required to maintain sufficient reserves and funds to pay for indentures, trusts, and similar obligations. Again, further obligations of the successor agency to perform those obligations, to remit unencumbered balances to the Auditor Controller's Office, and dispose of assets. Again, continuing duties. These are all taken from the various sub-provisions of 34.177. We have prepared an administrative budget, which is also on your agenda today for approval, and that includes the statutorily mandated administrative cost allowance that you'll see, which is a minimum of $250,000, or 5% of the first administrative budget for the first ROPS, and then 3% of the second ROPS, which we'll get into in more detail later. Certain contracts are considered valid, and others are considered invalid pursuant to the law under 34.178. The invalid contracts are defined, or they're ones between the city and its former agency, or the city and county, but they can be re-entered into under certain circumstances with the Oversight Board's approval. Valid contracts are ones that evidence defined indebtedness. RDA startup contracts that would be within the first 2 years of the agency's commencement. That would not be related to the project area commencement, and joint partnership agreements. As indicated previously, the city did elect to retain its housing funds. Later on your agenda, you will see an item where we're asking the Oversight Board to just simply affirm the action already taken by the city and the successor agency to have the housing authority serve as a successor housing authority. And also pursuant to statute, all the rights, powers, duties, and obligations pertaining to housing are also transferred to the successor housing authority. That, again, comes later in your agenda. I know that you've all had training in oversight board duties. Again, these bullet points just simply reflect the individual statutory requirements for the oversight board. Probably one of the more critical components of that is that the approval of the ROPS today is not the final stop in that process. That, as you are probably aware, the Department of Finance has 3 days after today's date within which to indicate its desire to take further review of the ROPS and indicate whether any or all of the line items included are acceptable pursuant to their review. What the Oversight Board is also permissively allowed to do is to negotiate with the city to purchase assets of the former redevelopment agency and to renegotiate or terminate certain contracts with certain findings where there is a showing of a reduced liability or a net increase of revenues to the respective taxing agencies. There was a field audit completed by the LA County auditor who hired independent auditors that will be visiting all of the agencies within the County of Los Angeles. The field audit component of that was completed on the 20th of April. What is being presented to you today is not the certified ROPS, in that we don't yet have a certification from the auditor's office. However, given the Department of Finance's directives that we obtain approval of the Oversight Board before May 11th, in order for them to review the ROPS, and so that we are able to pay the obligations as listed come the June 1st disbursement, we are asking the Oversight Board to consider the ROPS and make their recommendation at this point in time, knowing that the Department of Finance will have its opportunity to review those ROPS for compliance with AB X126.
I'm sorry, so we need to have the ROPS audited.
But
they're due before the audit's set to be complete.
It needs to be certified. We have to have a certified audit, but many agencies, many oversight boards are just meeting. And there's understanding from the Department of Finance at this point, this is my understanding, that the main goal is to have the oversight boards review those ROPS with the disclosure and understanding that the certified audits have not been completed in the County of Los Angeles. We are to understand from the independent audit firm that came here that we are the first agency within the entire county to be audited, and that audit for us is not yet complete. So therefore, the expectation from the Department of Finance is that the oversight boards, commence their obligations, review the ROPS, and make their recommendations to the Department of Finance with the disclosure that this is not based on a certified ROPS.
But the statute says we're supposed to have the audit, have the ROPS certified by a date certain.
Yes, they do, but
and they're not going to penalize us for not.
We don't know what their response will be. We just know that it's not certified at this point in time, and that we are waiting for further instruction, which is within the purview of the Department of Finance and the Auditor Controller to recommend procedures at this point in time for purposes of complying with AB 1X26 to the best of the oversight boards and the successor agency's abilities.
Bill?
Ms. Van Meiden, I called because of my role in this. We've sent the ROPS and all the payment schedules to the Department of Finance and to the county, so they've had it for some time. It's just a pro forma, not a pro forma, we need to have it, but an audited, a completed certified audit.
That's correct. Both the former agency and the city and the successor agency have reviewed and approved the ROPS. Those ROPS have been, as required by statute, sent to the Department of Finance, to the State Auditor Controller, and the County Auditor Controller. Those organizations have been requesting documentation and backup, and there has been a high level of interaction between staff from those departments and the city staff in terms of responding to their questions and providing documentation and backup. So at the point that the Department of Finance sees our ROPS, it will not be the first time. In fact, I believe, and Ms. Babolian can correct me, that they have been actually reviewing our ROPS as approved by the Successor Agency and by the city, the former redevelopment agency, before its dissolution for a period of months.
As early March.
And to date...
Leads me to ask a question then. I received email yesterday, a priority review items, and I don't know if you have a copy of that or not, but in some respects it seems to be a challenge to some of the items that are in the ROPS. And
I don't know from whom that correspondence is.
Pardon?
I'm sorry.
Well, I have it here, and it's a rather lengthy list, but have any of us received anything like that?
Yeah, I think the parties that were actually nominated by the county supervisors were actually emailed.
You received it?
I have received one, yes. It was just an informational piece that was sent by the county to the parties that were appointed by the county supervisors.
We will be...
I'm sorry, you have information that the rest of the board does not?
I have information that was sent to me last night on an email that I'm assuming you guys won't have.
It came in yesterday, and I think we received the same thing, and it relates to several items, and it comes out by page with respect to that. Page 1, page 2, 3, and then...
About 4 pages.
Chair Raggio, since this is more of an overview, we will be getting to that item later, and then when these specific issues that are in your email come up, then we can address those specifically at that time, if that's acceptable to the board, because that is...
Sending to you the copy I have, and then maybe at some time copies can be made for everybody, so we'll all look at the same list.
We'll ensure that that happens. Thank you very much. Were there any further general questions concerning the certified ROPS and the directives of the Department of Finance at this time? Yes.
Yeah. If the board approves the ROPS that's here and the audit comes up with something that's of a difference of opinion, how does that affect what the board has approved?
We are not certain at this time, because there don't appear to be there's not specific rulemaking or procedures or guidelines concerning how a certified ROPS coming later than the board-approved ROPS, how those adjustments will be made. We just don't know at this time. Moving forward, the way that the distributions of property tax funds that are collected by the county auditor controller will work is much different from the form of financing that the former agencies used to undertake, and that is it was more of a retrospective financing, and this is a prospective financing with a projection and an anticipation of the amount of payments that are necessary under their enforceable obligations for distributions to be made twice a year. Again, June 1st, and then it will be in January of 2013. And that distribution waterfall is first to the pass-throughs, actually, and then it's second to the successor agencies to pay their enforceable obligations. Administrative allowances come third based on those percentages, and then the remainder would go to pass-through payments based on an AB8 tax sharing reading. And that has to do with allocations to be sure that it doesn't violate Prop 1A. Just briefly, and I know that you're probably mostly aware, there is a slew of pending legislation out there, given that AB X126 was drafted rather hastily with limited review, and there are just, AB 1585 is the most comprehensive piece of cleanup legislation. There are 50 substantive changes that are recommended. It includes addressing what happens with the low and moderate income housing funds, whether those can remain with the housing authority. Other issues include whether or not the successor agency is a separate legal entity, and this is relevant from the perspective of being able to transfer properties and dispose of assets. And the status of that bill right now, it is an urgency measure, and it's in committee. It requires a 2/3 vote. So that's just a little rundown of some of the recent committee visits it has taken. You can see at the last bullet point that the affirmative votes were fairly significant to date. The second piece of legislation sponsored by Dutton is a bond, has to do with the bond proceeds. There is a significant amount of confusion, I don't want to say some, but concerning the status of existing bonds and what will happen to their unencumbered proceeds. This will modify it so that bonds that are issued on or before the 31st of December 2010 can be used for the purposes for which they were sold, and that will allow some time for the former agencies, or the successor agencies, I should say, to enter into new third-party contracts for purposes of using those proceeds. Further provisions of SB 986. And there are some concerns I just want to highlight for you concerning recent amendments to the bill, which further limit the ability to use those bond proceeds, and that it essentially potentially rendering the bill itself not as useful for purposes of correcting or assisting with clarification of the use of proceeds. So there it's a stay tuned. The status of that is as well as an urgency measure, and the status as of late last month that it's set for hearing very soon, next week, so it's going in and out of committee at this moment in time. Another piece of legislation, 1156, Community Redevelopment and Housing Joint Powers Authority, would enable the community development, the cities and the counties to establish JPAs that would assume the successor agency responsibilities and to establish additional sales tax funding to sustain economic development, affordable housing.
That sounds an awful lot like redevelopment.
It does sound like redevelopment in a different suit of clothing, indeed. So we're monitoring that bill, and here's the status. It is active. It is not an urgency measure. It wouldn't potentially take effect until next year.
So at this time, literally, we are taking apart redevelopment and putting back together redevelopment all in the same frame of time.
It appears that way.
How is the joint powers agreement defined in this case?
I don't have that bill right in front of me, and I can certainly provide that information to the Oversight Board if there's interest. But I don't have the bill in front of me to indicate exactly how that JPA would be formed. But it would be between the county and the city, and the focus would be on more regional projects, and it would be on infrastructural projects, and it would be on specific urban renewal type of projects that may involve mixed use with maybe disposition to private entities. So this is just sort of a little bit of a nutshell of my understanding of this bill. Again, it's a majority vote bill. It's a non-urgency measure. It has had some majority support on voting in committee, and is moving forward. Another piece, 1151, long-range asset management plan permits local jurisdictions to use alternative process to administer the former RDA assets. Again, another form of redevelopment, to quote the city manager and board member Scott Ochoa, for the use of former redevelopment assets for economic development and housing purposes. It is an active bill. It requires a majority vote. It's also a non-urgency measure, so this is not something that we would see, and it's essentially a piece of fix-it legislation for AB 1X26 in terms of its current implementation. But just to put a sort of a pin in it and note that we will be looking at potential modifications in legislation that could affect the existence of successor agencies, oversight boards, and the implementation of the duties and procedures. Another bill
that would require then revoking item F, which is the affirmation of the housing assets.
It would certainly change potentially some of the actions that we take today. Yes, that we're currently statutorily required to take.
So, to quote the famous lawyers, it's a work in progress that we're.
And up in Sacramento, it's a little bit like making sausage. Pending legislation. So 1151 again, a majority vote, not urgency. This is the Housing Opportunity Trust Fund Act, and this is an interesting mechanism that would establish a permanent source of funding for affordable housing by charging fees on recordation of real estate transactions. So it's an interesting approach to fundraising. Again, it's a non-urgency ordinance, but it does require a 2/3 vote. It's set for hearing as well on May 7th, and there appears to be again, majority support in committee for the bill as it's moving forward. I think that's the end of my slideshow, and I'm going to turn it back over to Elena to take us through the substantive part of the agenda. Thank you.
At 4 is action items, and 4A is Oversight Board administrative actions, officers, lead contact, and clerk. At 4A1 is resolution affirming selection of officers pursuant to California Health and Safety Code, Section 34179, designating Elena Bobolian, Senior Executive Analyst of the Community Development Department, as lead contact with the Department of Finance, and designating Ardashis Kasakian, Glendale City Clerk, or his designee, as the official responsible for the custody and safekeeping of official records, compliance with the Ralph M. Brown Act related to the preparation and posting and distribution of agendas, minutes, and supporting materials, as appropriate, and filing officer duties pursuant to the Political Reform Act of 1974 as amended.
Board members, I'd like to just present that these are some administrative actions that we need to take as part of the act, and as the state wanted to know the names of the oversight board members, including who the elected chair is by May 1st. And since our first meeting was today, May 3rd, we did want to provide them with the names of the appointed members as of last week when we sent them the notification. Mr. Steger was appointed on May 1st, so his name was not included. Following today's meeting, we will revise that letter to include Mr. Steger's appointment and also let the Department of Finance know who the chair and vice chair are. Are there any questions for item 4A?
If there are no questions, may I have a motion of approval?
So moved.
Second.
Board members Abkarian,
Yes.
Lansifan,
Aye.
Nakasone,
Aye.
Ochoa,
Aye.
Sheehan,
Aye.
Steger,
Aye.
and Chair Raggio.
Yes.
At 4B is Oversight Board Administrative Actions, Rules of Conduct, Meetings and Conflict of Interest. At 4B1 is Resolution adopting Rules of Conduct for the Oversight Board, selection of meeting time and location, and authorizing the preparation of a Conflict of Interest Code for the Successor Agency and Oversight Board.
Before I pass it on to Ms. Van Meiden to discuss rules of conduct and conflict of interest, I just want to touch on the meeting schedule for the board members. We've been in touch with the board members to determine a date and time that works with all of your busy schedules, and it seems that the first Wednesday of each month between 2:30 and 4:30, with the exception of Mr. Steger, we haven't had a chance to check with your schedule. So if you could let us know if that works, that would be the set time going forward. We do have one.
Just so you know, that's the only time that I've said that it won't work for me. When I was talking to the staff, I said the only date that won't work for me would be from 2 to 5 on Wednesdays, and to pick 2 to 4 on Wednesdays and say that it works for most of the people, it's just unbelievable. But that's fine. That's fine. If that's the date, then I have to make substantial arrangements for a pre-arranged commitment that I had, and that's the only time slot that I told the staff that I can't make.
Was there any other day that was
Our understanding was you were not available Wednesday evenings, but we will check with your staff again and find an alternate time that works for you. So we will table the set schedule and return back to you with a time that works for everybody, including Mr. Steger. However, we do want to see if Wednesday, May 30th, if you could make that one meeting, a special meeting Wednesday, May 30th, and that's primarily because we won't be able to meet during the 4th of July holiday, and we wanted to, get the board together in the summer months as we're going to have numerous items, and in the fall it'll taper off. So if Mr. Abkarian, you can attend Wednesday, May 30th, we'd like to keep that.
That's at 1:30 also?
That's from 2:30 to 4:30. If it's not doable, then we will find an alternate time.
Fine. I mean, either I'll be here or I will make it. That's fine. That's fine.
So going forward, we'll find an alternate time that works for everybody's schedule. Okay, I'll pass it on to Ms. Van Meiden.
Thank you, Ms. Bavolian. Chair, members of the Oversight Board, just very briefly, a draft of the Code of Conduct for the Oversight Board has been included. There is a blank that will be filled in with the agreed-upon meeting date and time. Please note that. And if there are any questions concerning the contents of that Rules of Conduct, which are pretty typical provisions concerning the operation of boards, I'm happy to answer questions for you. Really no presentation necessary concerning that. The Conflict of Interest Code, Form 700, to the extent that those have not been filed, the governing, the filing body for Form 700 Conflict of Interest is the City Clerk, City of Glendale. And if you are also filers in other jurisdictions, I recommend that you consult with your counsel, legal counsel, although there is some FPPC information, a letter that was included with your staff report concerning where those filings should be made and any amendments that might be necessary because of the additional interests that might be affected by your role as an oversight board member. The third component of that is the conflict interest code itself. Pursuant to the FPPC's letter, will need to be updated and, actually repealed for the former redevelopment agency, and a new one needs to be adopted both for the successor agency and the oversight board. And because the interests that are affected by the actions of the oversight board and the successor agency are essentially the same, there are two approaches that can be taken. One is just to amend the former conflict of interest code for the redevelopment agency, and that governed those assets, the jurisdiction of the redevelopment agency, which is essentially the same jurisdiction as the oversight board and the successor agency, or to draft a brand new code. In either event, that would need to be completed within 6 months. And so with the oversight board's direction, the successor agency staff will undertake completing that code, and the governing body, the code body, reviewing body for the oversight board and successor agency is the city council. So that will be brought to the city council for their approval within the 6-month period.
Is there a time limit with respect to that?
With respect to the adoption of a conflict of interest code, yes. Its deadline for a new agency to submit its proposed conflict of interest to the code reviewing body is no later than 6 months after it came into existence. So the date of existence would be today. And that's pursuant to Government Code Section 87303. For purposes of the conflict of interest statement itself under Form 700, it's within 30 days of assuming a new office. So I would request that the board members review the FPPC letter and to consult with your own agency's counsel concerning compliance with that. And that concludes my presentation concerning the rules of conduct and conflict of interest in the code, unless there are any questions.
Questions?
There is a resolution for the Oversight Board's consideration.
I'll entertain a motion to accept.
I move to accept.
Second.
Roll call, please.
Board members Abkarian.
I do have a question. Are we approving the resolution for rules and conduct, the oversight?
Yes.
I do have one question for Gillian. Actually, I apologize. It's like my brain. I went daydreaming for a second. And my understanding was that some of the voting had to have a minimum of 4 votes in this. I'm not sure exactly which voting it was, but some of the voting must have, regardless of how many people actually show up, must have 4 votes before you can actually have an action. And it says the majority of the votes of the total membership on the board is required the board to take action. Does that mean four votes on every? Even if there's 4 people here, all 4 must agree to it?
That's correct.
Unanimous vote. Okay.
So 4 is the number we work to then.
That's correct.
Even though a quorum constitutes 4.
A quorum of the board is 4 votes.
And it's not a majority of the members that are in attendance if you have a quorum.
That's not the way that it appears.
Thank you.
Sorry about that.
Does that answer your question?
Yes, it does.
All right. A roll call, please.
Board members Abkarian.
Yes.
Lanzafin.
Aye.
Nakasone.
Aye.
Ochoa.
Aye.
Sheehan.
Aye.
Steger.
Aye.
And Chair Raggio.
Yes. Item C.
At 4C is Oversight Board Administrative Actions, Request for Proposals for Legal Counsel. At 4C1 is Resolution authorizing the Successor Agency staff to issue a request for proposals to solicit outside legal counsel services to the Oversight Board.
Mr. Chair, members of the Oversight Board, I'm available for questions. I did present earlier, in my earlier presentation, I did indicate what the concerns were in terms of conflict of interest, and therefore the recommendation is authority for issuing an RFP for outside legal services. Within the administrative budget, there is a amount reserved for that purpose. as part of the successor agency's administrative budget.
Quick question. What might be the turnaround time for the RFP and selection?
We would ideally like to have a council in place for you before your next oversight board meeting. If there is unless the oversight board seeks to approve the RFP before it's issued.
That would be the May 30th.
The successor agency, because of the concerns for conflict, would prefer to be able to issue it based on the information that was provided and with an ultimate selection up to the oversight board.
So
and bring that back to the oversight board.
So we will be giving a number of choices, and from those choices we will actually choose a firm that would. Okay.
Correct.
Again, by the May 30th meeting.
May 30th.
So we could take action at that time on
That's correct.
All right. Thank you. So this requires an approval on the part of the board as well?
I'll move the resolution.
So the resolution is directing staff to issue an RFP and bring in names of people who respond to the board on May at the end of May, in the May meeting, at which time you will select one of the people who will submit proposals.
I second the motion.
Thank you. Any further discussion? Roll call, please.
Mr. Chair, I just had a question. When I read the proposal, I thought that the board was going to actually put together an ad hoc committee to work on this. Is that?
If that is the desire of the board, we could by all means do that.
Mr. Chair, I think Mr. Steger, if I understand you correctly, you're saying perhaps we should select an ad hoc group right now.
Well, I actually thought that in the proposal it said that we were going to do that, and so, but I think there is a choice whether we can have an ad hoc committee or do it as a committee as a whole.
Is it necessary?
To the extent that, well, is it necessary?
There's no statutory direction one way or the other in AB 1X26 concerning the procedure for selection of an outside counsel, counsel for the oversight board. So you can do it either as an ad hoc committee under direction of the oversight board, or you can give the successor agency the authority at this time to issue the RFP and bring names back for you for selection.
To answer that question, the only benefit that we could see is that if it gives more comfort level to all members of the committee that you have been involved in the selection process, that would be the benefit to you. Otherwise, if you'd like to give staff that direction and bring you what we received, that's also available. But by all means, it's completely doable to work with an ad hoc committee if you so desire.
What does the
Time
board?
is of the essence, I think. I don't know about you guys, but yeah. I would just as soon move forward, have the staff do it. Back to us.
I would agree with you. I would agree.
Is that good with all of you?
Yes.
All right. That's, see, we have a motion on it in a second. Any further discussion? Call a roll, please.
Board members Abkarian?
Yes.
Lansifin?
Yes.
Nakasone?
Yes.
Ochoa?
Aye.
Sheehan?
Aye.
Steiger?
Aye.
Chair Raggio.
Yes. Next item, please.
At 4D is adoption of recognized obligation payment schedule, the ROPS, for a period of January 1st, 2012 to June 30th, 2012, and for July 1st, 2012 to December 31st, 2012. And 4D1 is resolution approving the January 1st, 2012 to June 30th, 2012 ROPS, and approving the July 1st, 2012 to the December 31st, 2012 ROPS.
Okay. For your item 4D, the ROPS, we have two exhibits which we have color-coded to correspond to the colors listed in the slide number 13. And this was our attempt to try to group items on these schedules to allow you to ask your questions for each of the items that are grouped together. So just to summarize, in August of 2011, we adopted a EOPS, Enforceable Obligation Payment Schedule, which was for the months of August to December 2011. Following that, in September 2011, we adopted an ROPS, which was for the months of January to June 2012. Then the litigation went on, and in December, the decision was given by the Supreme Court. In January, we went back and looked at the initial recognized obligation payment schedule that we adopted in September, and we revised it. Given all the confusion with the bill, the dates, and the language, and the challenge, we incorrectly titled that the EOPS, but the dates were January to June, so it replaced what we did in September. So the only correction is that this should have been titled the recognized obligation payment schedule. And some items, when we prepared the list in September, were grouped together, and when we went back and revised it, we broke them out. For example, we have a facade reimbursement program where we had lumped everybody under one line item, and if you go back to the January schedule, you'll see it broken out by each of the property owners that we were working with. This January to June schedule is also referred to as ROPS 1, and the one that's for July to December is referred to as ROPS 2. So I will be referring to them as ROPS 1 and ROPS 2 going forward. To summarize Exhibit 1, which is ROPS 1, there are 3 sheets, and they correspond to the 2 project areas in Glendale, which were the Central Glendale project area and the San Fernando Road Corridor project area. So Sheet 1 lists the items that are enforceable obligations in the Central Glendale project area, and Sheet 2, San Fernando Road project area. Sheet 3 is the enforceable obligations of the low and moderate income housing fund, the 20% set aside. The total obligations for ROPS 1 are approximately $70 million, and we've grouped them under bonds, loans, administrative expenses, development or other types of agreements, pass-through and county fees, and other. And I want to point out that when we did our ROPS 1, we did include pass-throughs and counties. However, in subsequent discussions with the county and further clarifications from both the DOF and county, we removed those from our ROPS 2 because the county was going to handle that on their own, and there was no need to list those on our schedules. So at this point, we would be happy to go over any questions you guys have on the ROPS, but that's the summary.
Well, again, with respect to the information that we received from the county, is any of this affected by that? I'm talking about the list that handed out.
Given that we were just provided with this list a few minutes ago, we haven't had a chance to thoroughly go through it and cross-reference it with our items.
Bill?
Ms. Babolian, as far as you know, has either Mr. Serrano, Ms. Munson, or Ms. Seifel contacted you to ask if any of this has been provided to either the county or the auditors?
No, none of those names sound familiar. As Ms. Van Meiden indicated, we've been in touch with both the DOF and LA County for several months, and we've spoken and emailed several folks in the property tax division, and none of these folks have contacted us, and my discussions with the county have been primarily providing them backup documents for the obligations that we have listed, but none of those names in this email have contacted me.
I'm sorry, can I ask just one quick question?
I need to actually make...
Are you Libby?
I'm Libby.
All right.
So, and I don't have a copy of what you have in front of you necessarily, but I'm Libby Seifel with Seifel Consulting. We're consultants to the county. How would you like to provide?
I don't know. I do want a clarification as to where they're coming from. And
okay.
Otherwise, if there is a question as to what some of these items have in the way of validity, I don't know if we can pass that today.
Right. So let me just explain our role and what what I think you're looking at, though I'm not 100% sure. Do you think I could just glance at it for a minute? Because I don't know. I just want to make sure it's what I think. Because I've actually been down in L.A. and not...
When you finish speaking to, I'll just need to have you fill out a speaker card. They're
Absolutely.
on the back table.
I'm happy to fill out a
record.
speaker card. Okay. So we are consultants to the county, and we have been working with county council. And this information was sent to county council for distribution to the county oversight board members. It was not for distribution to everyone, though I understand why it was provided. Secondly, our task was to look at the ROPS and identify items that the Department of Finance, in their question and answer and letters that they've been sending out, what are items that they've flagged and have been concerned about, as well as items that the County Auditor Controller's Office had flagged. So there were a series of items that were the subject of the audit that was talked about earlier that I understand the auditors have been here doing a field audit. However, we did not receive any of the information from the field audit professionals, and we checked with the AC's office, and they actually didn't have the records, the supporting documentation. So they're trying to get that, but we just have not had the benefit of any of the backup documentation. And we did have a conversation with one of the oversight board members, Mr. Steger, and he had not received any supporting backup documentation ahead of this meeting. So specifically, we're providing advice and support and training to the oversight board members, and so really this information was really developed to help benefit Mr. Steger and the other oversight board members so that they could actually know what questions to ask about the ROPS.
One quick question.
Yes.
When was Mr. Steger appointed?
He was. We worked on this yesterday.
So, I mean, it's unlikely that he would have been able to get any information because you just got appointed.
Right. Exactly.
Before this.
Exactly.
So. Oh, please finish.
So a lot of these appointments have been happening very quickly, but it was our understanding. We checked with county council, we checked with the auditor controller's office. No one had any supporting documentation on these ROPS items that had been provided to the county directly, to county staff directly, because we always do that first. We check to make sure. So specifically, the items that we flagged here, and again, we did this very quickly in looking at the ROPS, and also we had trouble locating the ROPS initially, so we found ROPS 1 was easy, but ROPS 2 was hard for us to find. I don't believe we found an agenda packet with the supporting documentation attached to it other than the what we found last minute. I think we didn't even get ROPS 2 till yesterday or the day before were we able to find it. So anyway, so that's our process. Our process has been to provide advice and training to board members.
Bill?
And that's what it's about.
Excuse me.
Yes.
For staff, don't we send those to the places designated in the statute, and don't we post those on our website?
That's correct. Going back to the 4 schedules that we've adopted, we've sent every single schedule to the LA County Auditor's Office with certified mail, and we have all of those copies in our office. Further, if you go to the LA County's website and you look at the list of cities, if you click on on the City of Glendale, our annual financial reports are there, and our schedules, our EOPS and ROPS are also there. Additionally, our finance department, going back several months ago, provided the county with bond documents. This is all above and beyond everything we've given to the auditors contracted by LA County. And their fieldwork started April 16th, so we've been providing these documents again. So since April 16th, they've had these documents. So I can't answer why they haven't provided those to you.
So, and I know that they're doing 71 cities at the same time, and so they're struggling with all of this. So that may be part of what the challenge is pulling all this stuff together. But we couldn't find the backup documentation for the ROPS items that were listed anywhere. So that was what we just couldn't
find. The statute didn't call for the backup documents to be posted on the website, so we provided the payment schedules which were required.
Right. But for example, some oversight board.
Let me just ask a question, if you don't mind. First of all, I wanted to say that what was provided was extremely helpful. If it wasn't provided to everyone, I wish they are, because I think that it should be provided to everyone. But what was provided, first of all, was extremely helpful. First of all, the items came to us very late. It came to us on Monday, I think, which should have been given to us at least. You should at least give us a week to review them, because what was given to us is so extensive that it is almost impossible for us to be able to review all of this with the busy schedules that we have on a Tuesday and a Wednesday and come here on a Thursday. So that's one thing that I will talk, I guess, at some point on procedural stuff. The information that was given was extremely helpful. It was helpful to me, at least, to understand some of the items that I should pay more attention to. What was provided to others, I don't think was included in this package here. If you've given someone outside of this board a supporting document, it's not here. And it should have been. You tell me statutorily it's not required. I want to see supporting documents. As a board member, I want to see the supporting document to see which each item is. So if you're providing it to an outside agency, we should have a copy of it too here. But if you weren't able to put it, see, this is what I'm saying to just slash Ms. Libby, was it? In here and just say why was this provided and everything is online and all of that. I don't think it's fair. I don't think it's appropriate. And I think if an item is being given outside of this board to someone, we should have a copy of it.
I'm sorry, sir. May I? I mean, just to go to that particular point, the very fact that this document, this list of questions, is provided to not everybody on this board is problematic.
I agree with you.
To the extent that we are required by the statute to adopt an EOPS or rather a ROPS by date certain, unless the state decides that they are going to waive this particular requirement or that particular requirement, means that we need to get this information out. By the Brown Act, we're required to have it out 72 hours in advance. Was it out 72 hours in advance?
Yes, it was.
At that point, we do have an obligation to move forward. I hear what you're saying in terms of wanting to have additional time, but I think the very notion that we're able to comply with the law and just comply with the law, not go above and beyond, is indicative of everything that Ms. Libby has indicated, that the county, in deference to the county, they're trying to do 80 cities or 88 cities with the limited means that they have. The fact that poor Mr. Steger, was appointed day before yesterday and expected to show up here on command from his employer, it shows that this entire process is problematic. The construction and demolition simultaneously of redevelopment is problematic. It almost feels as though we can power through, knowing full well that the Department of Finance, the State Department of Finance, is going to reject this. They're going to send it right back to us. Even if we go through and parse out different pieces of it, it really doesn't make any difference at all.
So why are we sitting here?
That's a wonderful question.
What you're telling me, my appointment here and just sitting in here is completely useless. I should call the county and say, why did you appoint us? A couple of members are saying we're completely a useless board and we should be disbanded.
I think your issue is partly with Sacramento, too. It's not just the county.
I mean, the editorials are very nice. I mean, I can make editorials right now. I don't agree with the decision in Sacramento or don't agree or agree with them, but we're here. We're given a task to do. And we should comply with the task that we need to do. What you're saying is an editorial. I agree with you or disagree with you. I don't want to even go there. I'm sitting here and I'm given a task to do by someone who appointed me to do it. And I want to do it to the best of my ability. But if you're telling me that the entire thing is going to be, let's approve it because they're going to reject it anyway and send it back to us, that for me is insulting, that I'm wasting my time sitting here.
The county, my view of this is that the county is complying with the law the same way that the city is complying with the law. I don't know that that's an editorial comment as much as it is a fact that we have to comply with the statute as it's been outlined. The problem is that the statute was thrown together very hastily and they're making up rules effectively as they go. If as board members we want to go through these items that were submitted to some of the board members, certainly we can. If we're going to do something, we may as well try and do it right. That said, I look at these and there are answers where we may agree to disagree as a board, and if it gets sent up, my guess is that it gets sent back to us by the Department of Finance. So if you want to...
I have a clarification on Miss Libby's role. So you're a consultant to LA County.
Yes, that is correct.
And so what is your role with us other than...
I have no direct role for you as part of the oversight. I'm happy to be a resource if you have any questions for me, but my responsibility is to Los Angeles County.
And did this email come from you or your firm?
Yes, it came from my firm.
Okay. Thank you.
Yes.
Mr. Chair, this is, Mr. Abkarian said it's very helpful for him, but this is where I think it's somewhat counterproductive. Many of these things that Ms. Seifel said we should ask for, her own employer has asked for them, or her employer's auditor that they hired has asked for them. So to receive this without cross-checking with her employer's other resources or the successor agency seems to me a bit counterproductive.
Well, as I understand it, the material that we sent has not been reviewed or in totality with respect. Is that correct?
All the documents that the auditors have requested have been provided to them.
I'm saying that Ms. Libby has not reviewed all of that material.
No. What has been happening with other oversight boards, just to be clear, is that oversight board members have been requesting supporting documentation, and it's been provided to oversight board members because they're the decision makers in this process. So I would like to just echo the point that you just made, which is that it is totally within your rights as board members to ask for supporting documentation. We did check with the county resources to find out if the information was available to us, but notwithstanding that, it's still within your purview as board members to understand the nature of this obligation. That's part of your fiduciary responsibility as board members.
I'd like to point out that this is our first meeting, and therefore all of the backup documents that have been provided to LA County and Department of Finance have been brought to this meeting so that if this board would like to take a recess and review any of the documents, they could do that. And Mr. Abkarian, that's a lot of documents. And that's partly why, it wasn't included with your packet.
Well, again, just to get a clarification, have you reviewed everything that's there?
No, sir, I have not. Because it was not formally given to the oversight board members, so there was no way for us to get it other than through the audit process. And the audit process, as was pointed out, they're not actually due to give their final certification till July, so they're still working through their whole process, so they don't have their official documents all together yet. So that's why we don't have it. It's because they're doing 71 at once. Not all of them have been assembled. I've been asking, and actually, he's here from the audit staff. They're just trying to catch up too. So
just a quick question. If we don't approve anything at this point, and we are going to not approve any ROPS until the audit is done, what does that timing do to Glendale?
Well, I'm pointing to a document prepared by the county, and I believe Ms. Libby's consulting firm, which says the deadline for Oversight Board to review and transmit second ROPS covering July to December is April 27th. We didn't have this meeting. This is our first chance to meet, so we are trying to comply with the deadlines, and I understand the county has until July 1st to complete their audit and provide it to the state controller. However, the other arm, which is the DOF, is requesting this. So the pressure being placed on you is because we're trying to comply with the statute.
Yeah, and it's true. The county extended that deadline into May from the April 27th deadline, but DOF has requested that all the ROPS be submitted by May 11th because they have a 13-day period within which to review it, and it's very important that the payments get made by June 1st. So it is a ridiculous schedule to echo what you were saying. We're all in this ridiculous schedule. And there are bond issuances and there are bond obligations that are on the July to December ROPS period that need to be met. Those obligations need to be met. So there is time pressure for there to be an approval of the ROPS. I think the question for you as a board is to decide how much deliberation you want to do on each of the ROPS individual items and particularly what kind of supporting documentation or information or clarification you'd like to get from staff. And then sometimes with the Oversight Board members' meetings, there's been like an introductory meeting, and there's been some time between the introductory meeting and the approval of the ROPS. You don't have that here. You're trying to do it all at the same time because of the time pressure.
I'd like to add that if the board does approve the ROPS, any items that come up as a result of the audit, they will just ask us to correct it on subsequent ROPS. So there is an opportunity to correct any items in future ROPS.
Does that answer your question, Albert?
No. What I wanted to ask was even something
Microphone,
more,
please.
Your microphone. I wanted to ask something more basic and legal, and I know we can't get a legal opinion, or we hope we can on this particular issue. Could some of the board members get a packet from the LA County that other board members don't have? That's our first question, because the answer is either yes or no, because if the answer is no, then we shouldn't get any packets that are not distributed to everyone else. That's my first question. And if the answer is no, the LA County could send some members that require information that the other board members don't have, then I'll follow that up with a different question.
Well, I think we can take care of that if the three of us are county here sitting at the table, and to include a member of staff, Elena for one, as a fourth copy, and then she can copy everybody.
No, I understand that. That's even more basic than that. I'm just asking, could we even get information from the county? Let's say if I don't want to include the staff, or I decided I get an email and I don't want to include the staff, is it something that I can do? When I ask for information, and let's say Ms. Libby sends me a full breakdown of the next ROP, can I actually say I don't want to give it to the rest of the board? I don't know.
Members of the Oversight Board, Mr. Chair, again, my name is Michael Garcia. I'm the city attorney, and as Ms. Van Muyden already explained, we can't really give you an opinion that might conflict, but I'll answer to the best of the view I would have. Unless it's a document that's attorney-client privilege, and I'm not sure if there is, frankly, we haven't looked at it, whether the county representatives to this board have an attorney-client relationship with the county. It would be a public document, and all the other board members and the city staff and the successor agency staff would be entitled to that documentation. I think that was your question. Is this something?
We might actually put in the rules that any document being sent to one member should be sent to all the members. This way that takes care of that.
And we would certainly hope that would be the case, that anything that's presented to one board member would be presented to all as a public record. To the extent it's not a public record, then that would be another issue. And we just haven't had a chance to give thought to that.
We all be informed of the same material at the same time.
So the rule should say that any material sent to one public member should be sent to the entire board as a whole.
And
period.
Is that agreeable to everyone?
Yes.
Sure. Definitely.
So
Mr. Chair?
The answer is yes, that's the way we'll do it hereafter.
Except there's a question.
Yeah, a question, Mr. Chair. I think it's we have a dilemma. In that, us as the Oversight Board, we have to make sure that that we're comfortable with the decisions that we make that's based on documentation that we don't have. Yet and still we're butting up against this date certain. And so it almost seems like, and I hate to say this, but it might be that we have to have another meeting really quickly to sort through this stuff.
Well, you mean before the 30th?
I do.
Bill?
That's the information that you would sort through, and would everybody commit to go through those?
I will.
If I could just address the
If
board.
I knew what I was looking for.
Right, and my suggestion would be, and it's up to the board to decide how they want to proceed, but the the request that was provided by Ms. Seifel, it's kind of, there's two categories. One is sort of request for backup documentation, and the other is a request for clarification or a comment that the county doesn't believe that's information that should be included on the ROPS. Maybe the board wants to proceed in a manner such as to ask questions of the successor agency staff to see if it can be addressed at this meeting, or if they want to proceed with waiting and to look at that backup documentation before deciding to continue this to another meeting.
As I said, if we have this, why not go through it? Why not ask the question? We have all the staff here, and I'm sorry.
I still have a clarifying question. I don't understand. Okay, so we have 3 members that were appointed by the county, but we're all on the same oversight committee, correct? Yes. And so I still am confused as to why the role of the county, is the county the oversight of the city? No. And so this is where I apologize. I thought I was a political science major and understood more, but I'm very confused here.
Mr. Chair, members of the board, Member Sheehan, if I could just address that. This is a perfect example of the inherent conflict of the Oversight Board's roles and duties being composed of members appointed from different public agencies, needing advice that's independent of both the county and the taxing and the other taxing entities, the city, to this board as to proper functioning. And therefore, as I said, and I'll repeat the disclaimer, that I represent the successor agency and the city of Glendale only, and apparently Ms. Seifel represents the county, and so those are 2 conflicting interests that are being represented at this time until that point that you can have an independent counsel to be advising you on these issues. I think we have to muddle through under the agenda that we have and to address the issue in front of us, and we have several options, I think, that have been pointed out. One is to address the issues as well as we can based on the letter, if that's your choice at this point, and determine what should be held over, if need be held over. Another option is to, you could recess for a period of time. You could instruct the staff as to those items you would like to see immediately. You could recess, have the staff flag and tag those items, and then come back after a certain period of time for your review. You could select certain items to review. There are many approaches to potentially handling your review of the ROPS today. It is entirely up to you. You could continue this meeting to a date certain. There are lots of options, and we're here to provide the information for you and the comfort level that you need.
Well, one of the things I think that would make me more comfortable if I was assured that the county had all the material that you see in front of you before asking the questions. And my impression is that you did not have that, for instance, the audit report, as you mentioned, and that, before posing the question. So consequently, maybe the county needs to review the questions with respect to that material.
Well, let me just put this in the context of the time frame right now for you to make a decision.
Answer that question, and then we'll talk about time.
So we have not reviewed all of these documents, as I've indicated. The question to me is what particular items that you would like to have reviewed that would have supporting documentation underlying them. The information was not necessarily included on the ROPS itself. So some of this was what was required to be on the ROPS. Some of what DOF is sending back to folks is asking different cities to actually include this information. So that was some of our notation in this. So there's a combination of some that require supporting documentation and some that are just questions that could be asked to staff. So I think there's two buckets of questions or comments, if you want to put them that way. And as far as reviewing the supporting documentation, just given how quickly everything is happening, in our experience, it's actually very helpful to have the staff talk about the nature of these obligations and what they are so that you can have an understanding of what they are within a meeting, so that you can actually hear from staff what these items are for and what they're about. So it's not, I don't think it would be as helpful for me to review them, since I'm not actually working for the Oversight Board. I don't think is necessarily helpful for you. I will,
well, maybe for clarification, who asked the questions?
So who asked the question? So these are observations from looking at the ROPS of the kinds of questions.
Did you do this?
Because this woman is causing.
Yes, my staff did it. But these were the kinds of questions that we thought that if I was sitting in your shoes. So we pretended that we were sitting in an Oversight Board member's shoes. That's the way we wrote this from that perspective. And these would be the kinds of information that is being asked throughout LA County by other Oversight Board members, and that's consistent with the questions that DOF has been asking and the auditor has been asking. So that's from the viewpoint that we did it, was what were the kinds of questions that you would be asking as Oversight Board members.
I have just a simple question, and I think it's for staff or for whoever could answer. I have just a simple question. Let's say item number 55 on the ROPS, the ROPS 1. I just want to go through one of them, just to clarify for me. Number 55 says 20% set aside, and I was told that set aside, that the $3.3 million is going to be removed as a line item. Is that correct?
The Department of Finance has indicated in their Q&A that that item is to be removed. I know there was a lot of confusion on this item earlier, as there are a number of guidances from DOF, but they've clearly put out a guidance that says that that is no longer an enforceable obligation.
$3.3 million is removed from this line item. Where does it go?
Oh, well, wait a minute. I'm not sure.
Does it go to the second one? Does it go to the second ROPS, or where does that $3.3 million go?
The Department of Finance has not indicated to our agency specifically that line item is to be approved. There's general guidance that are provided to agencies statewide, and so until we are told by the Department of Finance, we will not remove that line item, because we may have specific obligations unique to our agency that make that an enforceable obligation.
I understand. Let's say that they said yes, it has to be removed, and that item is removed. Where does it go? Where does that $3.3 million, where does it go in the accounting, big scheme of things? Where do we see that $3.3 million again?
Ultimately, I believe it goes to the county trust fund, doesn't it?
And to be distributed to the taxing entities.
Okay.
That's correct.
That's what I wanted to know.
So that specifically is, part of the role of the fiduciary responsibility of the Oversight Board is, one, to the taxing entities, because the funds that do not get passed through to the Successor Agency for payment of obligations get distributed to the affected taxing entities. And it's also to the bondholders and to whoever has contracts with the agency, whatever are enforceable obligations. It's a dual role to meet both of those obligations.
But effectively, it would appear that what we have is a shadow staff. We have the staff to the Oversight Board, which is in the person of Ms. Babolian, and then we have staff supplied by the County of Los Angeles through consultancy to go through and look over the shoulder of the staff, which is what the role of this Oversight Board is. Actually, the role of this oversight is to oversee what the Successor Agency does.
Mr. Chair, members of the Oversight Board, if I may, I think it would be important just to revisit what the statute requires. And what the statute requires, and I'm reading directly from AB 1X26, is that a recognized obligation payment schedule, shall not be deemed valid unless all the following have been met. And that is, a draft recognized obligation payment schedule is prepared by the Successor Agency for the enforceable obligations of the former redevelopment agency, and mind you, the dates were modified by the Supreme Court. From January until July. The initial draft of that schedule shall project the dates and amounts of scheduled payments of each enforceable obligation for the remainder of the time period during which the redevelopment agency would have been authorized and obligated to receive property tax increment, had such a redevelopment agency not been dissolved. and shall be reviewed and certified to its accuracy by an external auditor designated. Okay, that auditor is not completed, and that audit's not required to be completed until June 1st. The Oversight Board, the certified recognized obligation payment schedule is submitted to and duly approved by the Oversight Board. It's the schedule that gets submitted and approved.
With apologies to my colleagues up here, because both Phil and myself have been living with this for the last several months. And so we understand a good deal of that shorthand, but I just want to ask for clarification, because to me it seems that these schedules comply with the statute.
That's correct. The schedules comply with the statute. The successor agency has reviewed the schedule and has approved it. What happens next is where the approved ROPS that's sent to the Department of Finance, then the Department of Finance has the opportunity, based on all the documentation that it and the county auditor controller has been collecting to date for months, will have its opportunity to review that schedule and to respond within the time frames set forth in statute, that 13 days within which to state the review, and then 10 days to provide a response to the submitting agency as to whether any of those items comply or do not comply. That is the role of the Department of Finance pursuant to the statute.
But isn't it our role to review the ROPS 1 and ask for additional documents if necessary?
It is to review the schedule. That's what the statute says. The role of the Department of Finance is to determine within 3 business days, pending a request for review by the department. Each oversight board shall designate an official to whom the department may make such requests, and who shall provide the document with the department with the telephone number. In the event that the department...
What section are you reading from?
I am reading from 34... sorry, I took it out of my...
I think it's 178. Or
Mr. Chair,
177.
34179.
Excuse me, Mr. Chair. Mr. Ochoa had made a suggestion, and Mr. Abkarian is looking for some information. Could we go through this? I mean, is that a start to get the information that you're looking for?
Whatever.
Go through and ask the staff to respond to it.
That's fine. I think that's fine. I think since this is our first meeting, we're getting used to the whole process. Whatever that process is, and I think we're confused about the process thus far.
I think it's fair that if he's got questions, if Mr. Abkarian has questions, to go ahead and ask the staff.
I'm still back where we have an obligation to meet a particular day, and then someone else, and this is Department of Finance as far as the state is concerned, audits us. They tell us that we're A or nay with respect to item by item. Is that true?
Correct.
Okay, then we take corrective action if we're a nay. If we are an A, then by the same token, it's gone. It's through. We don't see it again. And then the county is also looking at it and challenging it to a certain extent. That's what this is here, as to the position that they have with respect to us. Is that true?
Correct.
Okay, so it's kind of the daisy chain of events, and it starts somewhere and ends somewhere, and that's maybe what we're trying to clear up right now is where does it start and where does it end? And it starts with the successor agency, I think, and works its way up.
Once again, another clarifying question. We talked about the April 27th date. Obviously, that's come and gone. Now, what happens if we don't meet May 11th?
We don't know, but I would like to point out that the Department of Finance, the same agency that will be saying yay or no, has been asking for these documents going back as early as March.
So you've been providing them to the Department of Finance throughout?
Correct.
Mr. Chair, may I make a suggestion? Given that there are a lot of questions about that, well, some questions that have been obviously provided by the county to the members that have been appointed by the county, and there's some discussion as to what the board is supposed to look at, and we have asserted that we think the job is to show you the schedule, and the supporting documents have been provided to this appropriate authorities. However, in the end, we know who the board is, and you are the board. And the successor agency staff is not the board, and any other shadow or non-shadow staff is not the board. To make it very clear, since you are in charge, we present to you the possibility of maybe we were going to make it easy for you so that you could have a shorter meeting today. If it's necessary to go into the details, we have prepared item by item presentation. If you would like, staff will go, this will be more timely, this will take more of your time. However, if you choose, we can give you a presentation on every item, and as you see the presentation on that item, you can look at the questions that were provided to the county appointees and see if you still have those questions, or maybe you don't. This will take more time, and it'll be a little bit more hectic. However, you have that option.
What's the wish of the board?
Some of the items are immaterial. I think they're not large amounts. I think if we concentrate on the large ones and maybe we need more information on those, then that would be better. And even if we have the information, I'm not sure we have the expertise on this panel to say, yeah, that's right or not right. So maybe those are the ones that. And it seems like the ROPS has to go either yes or no. I mean, we're submitting a ROPS or we're not. It's almost like. Do we highlight the ones that we're not quite sure of to the Department of Finance, because that's the group that's going to ultimately say yay or nay on this ROP. So that would be my suggestion. If we highlight the larger ones.
Can we add to that suggestion as we go through with respect to this that we include these and in a response to the county, so that's on the record too.
I'm not clear on your direction.
Well, as you go through these, this relates in particular to certain ones on page 1, and they're bullets, as you can see. How do they relate to this? And is there a question about an item in here that can be clarified by you with respect to what's on this?
I guess my response would be we will take direction from the Oversight Board, so if you would like to go through that and ask questions about specific items and then direct us to do that, we will do that. But I don't feel compelled to take that list and remove items from the drops if not directed by you.
Maybe, though, going to Mr. Nakasoni's point, I think there's a great deal of wisdom in that. Because if you look at one of the things that was given to us here, there's a bullet point. I'll read it. Various leases, grants, and agreements. Successor agency should indicate date of agreements, creating obligations depending on date of agreement entered into. Item may not be enforceable. Those, I'm presuming, are all of the items that are listed here that are relatively small dollar amounts. Whether or not we want to pour over each and every one of those facade improvement agreements, I suppose we can. I don't know if that's the best use of our collective time, or even the county's for that matter, as opposed to some of the larger dollar items.
But I would like to make a suggestion. Maybe we take a 10-minute recess, look at the county document, and compare it to the ROPS, and then be able to come back and say, I'd like to ask about this, this, and this. My suggestion.
10 minutes? Is that good?
I'm by me.
Quarter of then.
Thank you.
We'll reconvene. We're recessed until quarter of. Well, let's call the meeting back to order from recess. And I think, Mr. Ochoa, it was your suggestion that we go through the list here and that staff answer the questions where there's a need to. And we're talking about these here. So if you don't mind taking them bullet by bullet, if there is no response to a bullet, just tell us so. That's it.
Can I add one qualifier, sir, on that? Is whether or not the item that's listed here is actually required by statute to be part of the ROPS. And, for example, as I look at ROPS 1 does not include the source of payment for each obligation as required. If there's concurrence, that's a correct interpretation, to note that. If there's not concurrence, that's a correct interpretation, to note that, and then move on to the next one. so we don't get bogged down too far in the minutia.
Can you do that?
Yes.
Okay.
Okay. So for bullet 1, ROPS does not include source of payment. The distinction between the EOPS and ROPS is that the ROPS should include this column. So when I was explaining that this should have been titled ROPS, that's one of the things that was not included. So we will make that change to Exhibit 1. If you notice on Exhibit 3, the source of payment is noted. So we will correct that to include the source of payment.
All right.
Because it's called for in the statute. Yes, and just to note, most of it will be requested from the redevelopment trust fund. Bullet number 2, ROPS 1 does not include the total outstanding amount. The statute does not require that the total obligation be listed. All it asks for is by 6-month total and then for each month. So it does not ask for the total obligation. That is something that the DOF has requested, but it's not required.
But that information is available should we desire it.
Correct.
Is that on our EOPS?
No.
The first schedule that we...
Here's the thing.
Now you're talking foreign.
When the DOF posted on its website the preferred ROPS format, that was March 15th. The schedules were adopted by the agency February 28th and January 24th, so we had no way of knowing that the DOF would request that. Again, if directed by you, we will add that column.
Again, it's DOF that will be the one who says yes or no. All right.
Okay.
Bullet 3.
Bullet 3, let's see. ROPS does not list dates obligation entered into and dates for obligation. Again, this is not something that is required. The DOF amended their format to request a column indicating when the contract was entered into. Bullet 4, the successor agency should provide a payment schedule for each of the bond series listed and clarify the timing and amount of bond payments. The 3.1 million bond payment is listed on ROPS 1 and not 2. It should be removed from ROPS 1. The bond documents provide the schedules, and we have provided all of the schedules to LA County. The ROPS schedule itself is limited in the amount of information we could put on there, so to the extent we were able to provide comments and notations, we did. One of the reasons we put the bond payment on the first ROPS was in discussions with LA County and our finance department. We were notified that we would not receive increment in the month of May, which as called for in the statute. And so it was our way of making sure that the debt service was paid. And so we put it on our payment schedule, knowing that it's for a future ROPS schedule, but that was the only way of assuring that we would have funds to pay those debt obligations.
And did the county advise that nobody in LA County would be getting that allocation?
At that time, it was based on a discussion just with our staff, but in subsequent trainings and notifications, they did indicate that no May funds would be distributed.
So we need these funds in order to make the debt service obligation payments or default?
Correct. The city loan agreement, item 5 on ROPS, page 1, may not be enforceable. Staff should provide oversight board with details on this loan agreement, including dates executed and amended. Again, this goes back to, city loan agreements dating back to the 70s and 90s, and every single time we have amended those, it's numerous documents have been provided to the county. And so... There are a few contracts that we did sign after June 28th, and I'd like to point out that we were one of the agencies that opted under AB 27 for the time that it was valid. So on July 19th, the agency passed an urgency ordinance to make it the payment at that time as required to operate under AB 27. So for a period of several weeks until the California Supreme Court issued its stay, we were opting under AB 27, which allowed our agency to continue, and so we did. And all of those were based on obligations. Meaning
I thought I was going to make this very easy, and you were going to say no, and we're going to move on. Of course, it's not going to be like that.
None of this is easy.
So are there, in this page 1 through 55, are there any obligations after January 1st of 2011?
Yes.
And are there any obligations that were entered into after June 28, 2011?
Yes.
Could we look at...
You want to cut to the chase and get to those ones?
I just wanted to see which ones are those.
Items number 12 through 18, which is contract for consulting services, they are lumped together, and as part of the audit with LA County, we did go through each of those and identify which one of those were entered into after June 29th. And
which one was?
It's problematic because we've grouped contracts together, and so I'm sorry I don't have that information at this moment.
Let me ask a clarifying question. Are all of these contracts in support of obligations that were entered into?
Correct.
Prior to?
Correct.
So these are in furtherance of enforceable obligations.
If I can give an example, one of our projects, if we had a contract with an architect that was drawing up plans for one of the projects, and his contract was expiring, we had to amend the contract. So we took measures like that after June 28, 2011, because we had to amend the contract in order for to meet our obligations. And so we didn't enter into any new contracts for new projects that are not listed here. So anything we did is tied to an obligation.
And that's 12 through 21.
Correct.
Okay, just to clarify, maybe I'm not very smart, but I just want to make sure that I understand it. And I apologize for taking time. Contracts from 12 to 21 were contracts with obligation and contractual obligations that the city had with contracting parties.
The agency.
That had to have been renewed based on a previous contract to finish the project. Yes?
There might be one or two contracts within these line items that we either amended after June 29th, or a new contract because a new consultant was needed in order to continue with the project.
But all of those were, and I think I know what you're asking. The redevelopment agency entered into enforceable obligations prior to January 1st, 2011.
Correct.
And in order to execute those obligations, they needed to enter into these contracts.
Correct.
And thereby, these are enforceable obligations.
Okay, let me just ask another question. Are there any enforceable agreements that were entered into that were not there prior to January 1st of 2011?
No.
Okay, I think maybe that's what I should have asked.
Is that satisfactory yet?
Yes, thank you.
All right. Go on.
The memorandum of understanding, this is for the items listed in blue. The statute calls for there's a section that talks about labor. Let me pull it up. Basically, this is the staff to carry out the work of the agency.
If I may, Mr. Chair, I think a couple of points on this bullet point. The comment that the MOUs between the city and the agency are likely administrative costs that should be paid by the administrative budget. That could be true, but it's also true that to the extent that the successor agency has enforceable obligations that it needs to perform these owner participation and disposition development agreements, then those costs related to those projects can be put into the ROPS independent of the administrative budget, and I think that's what this reflects.
Deal with the Disney where we have to expedite their process and their staff dedicated to a handful of projects.
Yeah.
Those staff, as part of that existing enforceable obligation, are covered here.
Correct. I mean, our view is that, and again, this is just the city and the successor agency's view, that the administrative budget is for winding down the affairs to the extent that the agency has, the successor agency obligations to dispose of assets that are not enforceable obligations. That's where the administrative budget is implicated. The other thing, there is a comment to clarify whether the former RDA was the actual employer. No, the city was the employer. But again, our view, and I think the Department of Finance has also taken this view, that those contract MOUs between the city and the employee organizations are enforceable obligations of the agency to the extent that they were paid out of agency funds.
So you would have staff that was operating agency activities under those agreements.
Correct.
Listed in here.
Correct.
As opposed to the city of Los Angeles, which is entirely different.
Had a different staff.
I mean, that was my question: was should it be in the administrative budget or not? But looking at these line items, you got a $6 million retirement line item for $1 million of salaries.
Which line item is
Oh, I'm sorry, maybe we're not there. It's actually number 9, $6 million of pension obligations.
$1 million a month?
Yeah, but the salaries, if you look at the salaries, the payroll's like $1 million.
If I can call a member of our finance department to explain that line item.
Mr. Chair, members of the board, I believe that was the accrued liability for all the past payroll for agency staff. Obviously, there's a lot of accrued amounts in there, and we listed them on there in total. It's obviously not the amount paid per month, but it's for prior unfunded liabilities for the pension. I think we were just trying to get everything on the list.
So really, it's up to June of 2012, up to, not from January to June.
The $6 million is for the 6 months worth.
It is then. All right.
That would be the payment. That would be the payment to the fund.
That was for the net unfunded pension liability for all the prior pension obligations for agency staff, for all those that worked in the agency. It's not just, I think, the amounts for agency staff for those months.
So it's a total.
So it was a total, I think we listed on there to be very safe.
Which the agency would have paid had it
Eventually.
remained
Correct.
in existence.
Correct. So there won't be that obligation going forward.
That's what I was going to ask. It drops down in subsequent ROPS.
Correct.
To a month-to-month.
Correct.
Ron, does that answer your question?
I understand how it's coming from. I just don't know if it's appropriate to be on here at this point.
The Comar investment supporting documents provided, the development and disposition and development agreement is provided for in these folders. Contracts for consulting services show report date of contract creating obligation. So when we revise the schedule to include the column requested by the DOF, we will add the dates the agreements were entered into. Various leases, grants, and agreements should indicate the date, same comment. City reimbursements, city should provide supporting documents and report date of obligations. If these obligations may not be enforceable, if payment from bonds and allowable under bond documents, these obligations may be enforceable. Yes, city reimbursement items 34 through 40. These documents, actually these projects listed under 34 through 40, if you look at our 2010 and 2011 bond documents, they do reference a agreement that was entered into January 2011, and that agreement lists all of these projects. County property tax admin will be calculated, and as I mentioned earlier, the pass-throughs and the county admin fee were removed from ROPS 2. Various projects should be clarified. That's item 54. And again, those various projects are clarified in that same document that we entered into in January 2011. It's referenced in the bond documents.
Microphone.
Sorry. I mumble so much that I turn it off so you don't hear my mumbling. If we don't agree with a line item and we say, no, it has to be removed, then what happens? Do we have to amend the ROPS and resend it to them? What happens then?
Basically,
I'm trying to understand the process.
your task is to review the schedule, and so if...
And we decide 50? We don't want number 42. We want it to be removed. What happens
So then what I would do is I'd go back, remove item 42, and then send that version to the DOF.
The new amended version goes to
Correct.
the DOF. Okay. Sorry about that. And the line item that's removed, the money from the line item that's removed does not transfer to the next ROPS. No. It basically transfers to the...
It goes back to the taxing entities.
Taxing entities, okay.
To the trust fund and then distributed.
Correct.
Okay.
20% housing set aside. The statute did not repeal the sections that require this, and so that is why we have included this on our schedule. Okay, let's see.
And you're on page 2?
Yes, ROPS 1, page 2. All comments from Central Glendale apply except the comment regarding Comar Investments, owner participation agreement with Walt Disney. Staff should provide supporting documentation. The supporting documentation for these agreements are included in that packet over there, and there is reference, Mr. Ochoa mentioned it, there is a section in the agreement that calls for dedicated agency staff in support of the GC3 project.
And when you send the supporting document to the DOA's office, does it get mailed or is it scanned and you can email it to them?
We've been, in order to be green, we've been providing them links on our servers.
Okay, then you can
PDF.
provide those links to us too for the next futures, right?
Correct.
Okay.
Correct. Same item applies for the OPA with KABC 7. Low moderate fund, staff should provide supporting documents for ongoing housing related obligations to be funded. I'm not clear on that. The MOU, this is the same response that Mr. Garcia provided with the agency staff. Successor Housing Agency administrative costs are responsibility of the city. When we get into our next agenda item, which is the administrative budget, you will see the distinction between the administrative staff and what's listed on the ROPS. Future Successor Housing Agency undertakings are not payable. This goes back to my comment about, let's see, future items 35 and 36.
This is the section that was not repealed?
Well, my number 35 and 36 are the county pass-throughs, which we will eliminate, so. Oh, page 3, okay. Yeah. Oh, I'm sorry. I didn't go to page 3.
Number?
We're at 35?
Yes, 35 and 36 on sheet 3.
Am I reading this wrong? Or 36 is 14,014, 14, 14, 14. Oh, I'm sorry. 414 then. Okay, never mind.
Yes, this is the same comment. The statute, these sections were not repealed.
Why isn't there anything for the soccer and it's actually listed here?
That's a good question. If you notice,
I want a soccer field.
There are some items that we've listed without a dollar amount, and that was our way of making sure as we go forward and review these ROPS and amend them every 6 months, that as a future obligation comes on, that we remember to put that on. And so since the schedules are just intended for that 6-month period, and time we prepared it, if we didn't anticipate needing any funds to make any payments, it's listed as a 0.
So 18 months from now, we may need to show...
Correct.
Yeah, okay.
But we will be recognizing it as an enforceable obligation.
Correct.
It just hasn't incurred any cost, has it?
Correct. Unless there are any questions on ROPS 1, we can move on to ROPS 2.
Questions?
Do we approve one now? How do we do this?
What's
Do we do
the
it by
process? Do we
stages, or-
approve one at a time?
There's one resolution, and it combines both ROPSes, so
All
if you'd
right.
like, I can conclude, and you can just move one resolution.
We'll take it then as the 2.
Okay, moving on to ROPS 2. The first comment, it notes that the source of payment has been provided, county property tax has been removed, pass-throughs have been removed, and other comments from ROPS 1 also pertain to ROPS 2. Okay, page 2. Okay, so if you go to page 3 of 4, which is the San Fernando Road project area, and you look at item number 9 and 10, which is Walt Disney Development Agreement and OPA with the Walt Disney Company. The comment from the county consultant is OPA DA with Disney has been split into 2 items with the successor named as payee for item 10. Should clarify the change in how these obligations are presented. The agreement with the Walt Disney Company is a long-term agreement. It's a 30-year agreement that was entered into back in 2000. And part of that agreement calls for the tax to be set aside by the agency in order to build public improvements that are of benefit to the region. And so the way we wanted to make sure this was captured was for us to list it as a separate item, because if we don't do that, then that tax gets sent over to the county to be distributed to the other taxing entities. So this was our way of showing that we need to create we have a separate fund, but we need to make sure that the allocated dollars are segregated and kept in that fund so that we can meet our obligations under that agreement.
So it's an obligation of the agreement?
Correct. Correct. And this was our only way of making sure that those funds were set aside, and that's why it's included in our payment schedules.
There's an enforceable obligation that requires these 2 items to be noted as they are.
Correct.
Yes?
Okay. And then moving on to...
That's item 10.
Yes, correct. That's item 10. And the reason it's the payee is the successor agency is because we would get the fund from the Redevelopment Property Tax Trust Fund, and we would set it aside in a successor agency fund so that that money is just used for those projects. And moving on to the last sheet.
I actually have a question on page, I'm sorry, you're on page 3?
3.
Okay, go ahead.
Actually, I moved on to page 4, which is the low mod fund.
Okay, let me just ask a question about page 3, real quick. Number 8, contract for consulting services of $1.7 million. What does that entail?
If you just give me a second, I'll pull up the detail.
The same is true with number 15.
Okay.
And just to ask the chair if that's possible, I usually get very nervous when I see various vendors or I see other services. Anytime you say other and various, is there can we not have a reference where you would tell us what it is?
If it's the desire of the board, we will break that we will break that down, yes.
This would make it easier for us not to just say various and 1.7 million and just other services. It will make it a whole lot easier.
Part of the reason we presented this way is just the way the contracts were set up with our finance department, but we will break that down for you.
Number 8 was?
Number 8, a bulk of that, over 1.5 million of that, is an agreement we have with the Southern California Railroad Authority. It's to fund some of the crossings, railroad crossings, that are actually required as part of the earlier agreement I mentioned with the Disney project.
And number 15?
Number 15. Number 15, administrative.
Administrative maintenance and operation.
Page 3.
Page 3, page 2, Rob's 3, page 3, yeah.
Page 3 of 4?
Yeah, 4. And then number 15 says administrative maintenance and operation, various vendors. What is that?
Okay. This, because we are city staff, it's more cost efficient for us to use the city's contract with, for example, the copier vendor, instead of the agency having its separate contract with the. So it's our way of reducing costs, and so that's why it's various. It's to pay, the copier machine. It's to pay rent.
Get that itemized as well?
Yes.
And so this is, let's say if we need copies for this body, you don't go and redo a new lease for a copy machine.
Correct.
You just use the machine
Correct.
and then you
Correct.
put the cost in.
Correct.
Okay, thank you.
And AB 26 allows those administrative costs.
Correct.
We're now on page 4.
Yes.
Any questions on page 4?
Several items associated with Glendale City Lights and Central City Lights have been added to ROPS 2. Items 8, 9, and 20. Staff should
That was
clarify.
from page 3, I think, right?
It's actually 4 because Central Glendale project area went on for 2 pages. So, but the questions relate to the low mod housing fund. Successor agency staff should clarify whether these are 2 separate projects and why they did not appear on ROPS 1. If I can call the housing staff to respond to this question.
Mr. Chair, members of the board, Peter Zovak, Deputy Director of Housing. These are 2 separate affordable housing projects. They were developed and contracted under redevelopment set-aside law and funds. Projects are operating, but they are not complete. They are in construction financing mode, and they need to convert to permanent financing. During the preparation of ROPS 1, the projects were operating and preparing to convert. During the preparation of ROPS 2, the problems became at risk of going into foreclosure, and so additional staff time and expenses were needed in order to protect this housing authority redevelopment asset through the foreclosure process.
If I could have you clarify, Peter, just so the record is clear, 8 is Glendale City Lights and 9 is Central City Lights. So, and Vassar City Lights is also on here, number 7. So 7 and 8 are the ones that were built and operational.
Correct.
Okay.
Thank you.
Further questions? Yes, ma'am.
Clarifying question. Sorry that I have it on my computer and not printed out.
Well, we have a question as to whether your question is appropriate or not.
Right. So it's totally at your pleasure. It's totally at your pleasure. Whatever you want.
Mr. Chair, I think the only way she can actually ask questions is if you're actually taking her comment as a public member, not as a authority on this particular issue.
Well, perhaps we can press through and then open up for public comment on this item?
Yeah.
And she can ask a question at that point?
Totally fine. That's great.
Do we have further questions with respect to both 1 and 2?
Seeing none.
I have it here.
Now is the time for you to come up and...
Sorry, I apologize. And I'm sorry about the awkward nature of all of this. But I just want to make sure that I want to actually address Oversight Board Nakasoni's question a little bit by asking a question to staff, which is, in last fiscal year or this fiscal year, what was your total tax increment received? Do you know what your total tax increment was received in the agency this past year, last year, recently? In round dollars?
Annually?
Annually.
Might it be better if she asks all her questions, or?
Well, no, do you want me to just ask them in sequence or whatever? I'm fine. I'm trying to get a sense, because it's from us looking at this. Let me just preface what my comments are about. So, this law is really poorly drafted from the standpoint of trying to implement it. So it's very confusing how to do it. So we have these two ROP schedules. These two ROP schedules pertain to fiscal year 2011-12 revenues. As was stated earlier, half of those revenues approximately have been paid to Glendale, and they were paid in January, and they in essence cover ROPS 1, theoretically. The second payment that's going to come June 1st is really the payment schedule related to ROPS 2. So the ROPS 2 is actually to cover the amount of revenues that's kind of coming from this second half of the year, from fiscal year 11-12. So the sources of money, from what I'm understanding, every line item that you've indicated here is really all coming from the Redevelopment Property Tax Trust Fund, if I'm understanding what you said.
Some of them, not all of them.
The majority of them, but I think as you were stating earlier, the majority of them was. So the revenues that are available to pay for that, for all of those expenses, come out of that Redevelopment Property Tax Trust Fund annual money, or they come out of reserves. They come out of cash reserves, if there are any cash reserves available that the agency has. So there's those two sources of money. You haven't distinguished on the ROPS the distinction between annual Redevelopment Property Tax Trust Fund revenues and what's coming out of cash reserves. In looking at this and adding up all of these obligations on ROPS 1 and ROPS 2, from what I can tell, and again, I'm not your finance person, these greatly exceed the amount of money that's coming in or would be expected to come in, likely to come in. And some of these obligations, for example, a pension fund obligation, is a long-term obligation, but not necessarily an annual obligation. So my big picture question is, because I think that was what was sort of being asked, is what are the implications of this? Well, one of the implications is that the Redevelopment Property Tax Trust Fund is, if there's no money left, after you pay all these obligations, after you make all these obligations, if there's no money left, there's no money left to actually pay staff. Because admin for the successor agency is the very bottom of the waterfall, so there will be no money to pay staff to administer all of these programs. And there will be potentially not enough money to meet other obligations. So, for example, bonds are senior to all of these other obligations. So there's sort of a priority of payments. So what's going to happen is the county auditor controller is going to take their county property tax admin fee off the top. They're going to take the pass-throughs off the top, and then they're going to remit to you based on ROPS 1 and ROPS 2 an amount of money, and specifically in June it's based on ROPS 2. So my big picture question is that, I'm looking at this also from the standpoint of, being able to make sure that you can administer your programs moving forward. It's just prudent to understand the nature of these obligations and what the timing of these obligations are and what really needs to be paid in what month. And related to the bond payments, we want to make sure the bonds are paid. That's very important to the county and to all of you to make sure the bonds are paid. So the question we ask specifically about the bonds is we want to make sure the bonds are paid, and at the same time we don't want to have them paid twice. Though if there's a need to reserve some funds to make bond payments, that's really important to establish. So that was related to a comment that you had made earlier. So I think those are, and the only other piece of this is the admin, theoretical admin amount is tied to the amount that's on ROPS 1 and ROPS 2. So there's an admin allowance that gets calculated. It's a kind of chicken and egg. It's hard. You don't know what it is till you know what's the approved ROPS. But one of the comments that we had been making was related to the administrative budget and how you were taking that into account.
Shouldn't you be making these statements to the successor agency?
Well,
because as I picture our role, we're pretty much an audit agency of what has happened in many respects, and an approval agency of what will happen, dependent upon what the successor agency does.
And I think that's a very good comment. But these it does relate to you, because if you don't have the successor agency staff available to you to staff your meetings, it does have an implication to you. So having an understanding, I thought one of the questions was having sort of an understanding of what the financial implications are of the decisions that you're making. And so that's what I just wanted to articulate back, because we want to make sure that this is working for, mechanically working, even understanding that the law is difficult to understand and navigate.
I think part of what you'll see is that folks that are doing this work are working themselves out of a job. I mean, 29 of them have already done that, and they're now gone unemployed. And so now we're looking at the folks that are going to be covered on this administrative budget. Once we have wound up the agency and have either sold off or put into permanent trust all of our obligations, those staff will then go away. And the costs associated with those staff people will go away as this thing winds down.
But it's in motion at the present time, and what we're talking about is ending the end of June, are we not? That's what you're really addressing. Happens to be this second ROP that ends in June 30th of this year.
Well, it's sort of confusing. The first ROPS actually ends in June, and the second one ends in December, but it's coming from the June payment. It's coming from the June payment of funds.
We disagree with that.
Excuse me?
We disagree with that. Because if you go back to the history of redevelopment, most of the agencies started off by borrowing funds from the cities, and so as they got tax increment from the county, they went back and paid back expenses that they incurred. So at some point, the DOF decided that they're going to pay forward. If you go back to the history of redevelopment, that's not how it works, and that's not how these payments and schedules were put together. And so I just want to clarify that.
Well, I think we've had enough discussion on this, if you'll pardon it, and thank you for your comments. They've been noted. I'll entertain a motion to approve ROPs 1 and 2.
So moved.
Second.
Discussion?
Mr. Chair?
Yes.
Mr. Chair, are we going to approve the ROPs with the additions of the what we talked about at first, the source payments?
Yes, we will alter the ROPS to make sure it meets the DOF template,
as well as those eliminations that were appropriate.
Correct, with the elimination of the county admin fee and pass-throughs. Correct.
Further questions? A roll call, please.
Board members Abkarian,
Yes.
Lansifin,
Aye.
Nakasone,
Yes.
Ochoa,
Aye.
Sheehan,
Aye.
Steger,
Aye.
Chair Raggio.
Yes, motion approved. Let's go on to item E.
At 4E is approval of administrative budgets for the Glendale Successor Agency. At 4E1.
Sorry.
I'm awake now.
Wake up call.
At 4E1 is resolution approving the Glendale Successor Agency administrative budgets for the period of February 1st, 2012 through June 30th, 2012. and for the period of July 1st, 2012 through December 31st, 2012, and authorization for the successor agency to enter into an agreement with the City of Glendale to reimburse costs to conduct oversight board meetings pursuant to California Health and Safety Code Section 34179.
Explanation, please.
Sure. For your review and approval is the administrative budget for 2 periods. The first period is, the statute calls for fiscal year 2011 and 12 and fiscal year 2012 and 13. The distinction is that as the redevelopment agency dissolved effective February 1st, the guidance is that the administrative budget just be for the period of February 1st through June 30th, which is a total of 5 months. And so as you'll see on the next slides, we have taken the costs of the redevelopment agency and have divided it with between 12 months and multiplied it by 5 months to comply with, with the new revised dates as issued by the Supreme Court. And so that's for the administrative budget for the first fiscal year. And if I go on to the next fiscal year.
Let's go back for a second, do you mind? Sorry about that. The 1.9 million is from when to when? July 1st until June 30th, 2012.
It's February through June. The 1.9 million results in staffing costs from February to June.
It's a 5-month period.
Correct.
And you netted out I'm sorry. Go ahead. So you netted out the period before the Supreme Court decision?
Correct.
Go ahead.
If you notice, when we go on to the next fiscal year, July 1st, the 29 staffing reductions that Mr. Ochoa mentioned are reflected, and the successor agency staff going forward, July 1st, is 6.15 FTEs, and that's 3.2 to wind down redevelopment obligations as listed on your ROPS, and 2.95 in housing staff to wind down the items related to the low-mod housing fund. The staffing costs are $941,309, $556,668 is for the redevelopment, and $384,641 is for the housing staff. Our maintenance and operations, including rent, IT, office supplies, and etc., are $704,428, which is a total of $1.6 million, and you are approving a 6-month administrative budget, and that's why we've divided it into 6 months worth at $822,869, which is for July to December. So what we're asking for you to approve is that $822,000 amount.
Is there a motion?
I have a question. I'm sorry.
All right.
The $704,428. What is the largest portion of that $704?
It's some of it is contracts that we have. For example, the consultant that we're going.
Because the $700,000 is almost 1/3 of the total amount of the fiscal total, and I just want to see. You would say 30% of it is rent, and that's what we're charging. I don't have any issues with it. I'm not saying it's too much. I'm just saying, could we kind of get an idea as to what the $704,000 is for?
We can provide you with a breakdown of that.
Okay, but I'm going to approve it now. Right?
What is it, Elena?
Let me point to the exhibit so that you can follow along. So that would be Exhibit 2, and there's 2 pages. So if I can read some of the items that we include under maintenance and operations. Rent, contractual services, direct assistance, repairs to equipment, repairs to office equipment, advertising, ISD, which is our IT charge, postage, training, liability, insurance and surety, office supplies, general supplies, reports and publications, printing and graphics, business meetings, miscellaneous.
And do you have a breakdown of those contractual services?
Not handy, but I can provide that.
That's okay.
For example, the legal counsel that you would be hiring at your next meeting would be included in that line item.
And disclosure counsel
Correct.
for bonds?
Correct. And any other consultants as we go forward that we may need.
Does that answer your question?
Yes, thank you so much.
Right. Ron?
The administrative budgets, I thought there was a threshold of 5% and 3% for fees. How do we know that we're not going over those limits?
That's a hard question to answer because as Ms. Libby indicated, the 5% and 3% is calculated off your ROPS, and so without having an approved ROPS, we have no way of knowing what that number is. So this is truly the cost for us to wind down the agency as reflected on this in this budget.
As a percentage, do we know what that is right here?
Of the approved.
Tell you.
Yeah, I could tell you.
We just approved the ROPS now.
Yeah, it's. I guess, let me go. This is 43 million, and this is 822.
I think it's below percent, isn't it?
2%. It's 2%.
Yeah.
Can we add in a percent? Just
Okay, you were doing good until then. Does that answer your question, Ron?
Yeah. What did you have as a total?
I had a total of 43,474,212, which is the total obligations on the ROPS.
Was that 1213?
Yes, that was 1213.
Because 3% would be like 1.2 million.
Well, it's the administrative budget is for 6 months worth.
Oh, I'm looking at the total. I'm looking at 1.6 million for what you're considering the total, and you divided that by 2.
Because you're approving 6 months worth.
So then the next 6 months.
Because the ROPS is also 6 months, so that 43 million
You're
is
right.
6 months.
You're right. I'm sorry.
It's okay. No problem.
Further questions? May I have a motion?
I move to approve.
Second?
Second.
Any further discussion? Roll call, please.
Board members Abkarian,
Yes.
Lansifin,
Aye.
Nakasone,
Yes.
Ochoa,
Aye.
Sheehan,
Aye.
Steger,
Aye.
and Chair Raggio.
Yes. Motion approved. We'll go on to F.
At 4F is affirmation of transfer of housing assets to the Housing Authority. At 4F1 is resolution pursuant to California Health and Safety Code Section 34181C, affirming Glendale City Council's resolution number 12-02, designating the Housing Authority of the City of Glendale to retain the housing functions and assets of the Glendale Redevelopment Agency, subject to reservations therein.
Okay, this is item 4F, and one of the administrative actions that we took back in January when we named the successor agency was we transferred the functions to the housing authority. And in Glendale, we've had a housing authority for over 20 years, and they were accustomed to providing that function for the city, and so it made sense for us to affirm that the housing authority going forward would continue to administer those programs and projects. And Ms. Van Meiden covered this in her presentation, and we took this action. The resolution is included in your report as an exhibit, and so we're just asking you to affirm that resolution.
And I think just to clarify, I think the Housing Commission is composed of the council and 2 additional people from the city of Glendale.
Correct.
And they're the ones who make the decisions associated with housing.
Correct.
Mr. Rodriguez, just a quick question. Do we need under the code to affirm this? Do they need our affirmation, or is this just something to be careful? Do they need us to affirm it? The city council has already passed it. They said they're transferring their plumbing. They have a right. I see that they elected to retain the housing and function, and they transfer it. Do we need to affirm it? Stuff that we don't need to do, I don't want to do from now on. That's what I'm asking.
There was some language, and let me point this section. I think it's 34180 or 34181.
While you're looking for that, while they're looking for that, what I've understood is some title companies are looking to the statute and saying, gee, we think you need to do that. And in fact, some transactions, I understand, have been held up because this action wasn't taken. They went back to the Oversight Board, took the action, and the title company approved it. So I do think it's perhaps a belts and suspenders, but there's no harm.
It also means that the Oversight Committee is no longer responsible for the housing. That's another entity, and that takes us out of the oversight of housing.
And if I may, the statute, as Ms. Boboyan mentioned, 34181 does provide that the Oversight Board shall direct the successor agency to do all the following, includes transferring all housing responsibilities to the appropriate entity. So the Housing Authority agreed to assume those duties. The agency, prior to its termination or dissolution, agreed to transfer those over. It's required. There's a reasonable case that it's required for the Oversight Board to make that determination as well.
So we took the action prior to your formation, and so we're just asking you to approve that.
Further discussion? May I have a motion?
So moved.
Any further discussion? Roll call, please.
Board members Abkarian?
Yes.
Lansifin?
Aye.
Nakasone?
Yes.
Ochoa?
Aye.
Sheehan?
Aye.
Steger?
Aye.
Chair Raggio.
Yes. Motion passes. G.
At 4G is direction to successor agency. And at 4G1 is resolution directing the successor agency to make certain determinations as required by California Health and Safety Code Section 34181E.
This is the last item for your review. The section that Mr. Garcia just read, 34181, if you continue reading that, subsection E asks for the Oversight Board to direct the successor agency to determine whether any contracts, agreements, or other arrangements between the redevelopment agency and any private party should be terminated or renegotiated to reduce liabilities and increase net revenues to the taxing entities, and present the proposed termination or amendment agreements to the Oversight Board for its approval.
Questions? If not, I'll entertain a motion.
I'm just trying to understand. Sorry about that. So the agency will determine any agreements that are no longer enforceable, and then notify us for us to look to explain what that means.
It's asking for the Oversight Board to direct the successor agency to do that, and so if you direct us to do that, then we would bring it back to you.
And if I may, it's also directing, the Oversight Board is also directing the successor agency to determine whether any of the existing agreements that are enforceable should be renegotiated or terminated if they have termination provisions that won't cause the agency to go into default. So basically, this is the first step for the Oversight Board to direct the successor agency to look at all the contracts and see whether there's any room for renegotiation.
And what's the exact motion that we were being asked to vote on?
It's a
resolution.
So it's a resolution making determinations as required by the Health and Safety Code, and it is resolutions of the the Oversight Board to direct the successor agency to determine whether, pursuant to California Health and Safety Code Section 34181E, any contracts, agreements, or other arrangements between the former redevelopment agency and private parties should be terminated or renegotiated.
And then, Mr. Garcia, so it goes back, the successor agency determines that if they think they should be renegotiated, they renegotiate them. The successor agency would approve that and then comes back to this board.
That's correct.
Shouldn't this have been done as part of the development of the ROPS? As we come up with what are the enforceable obligations, shouldn't we have kind of looked at the contracts that we shouldn't have continued with?
Again, I think just with the timing, the first step was to try to get the ROPS done, and then we do want to follow through on this statutory obligation that we also have.
So the contracts that are renegotiated will be renegotiated with a condition that the OB will approve it.
Correct. Absolutely.
Correct.
Chairman, is there an opportunity for comment on this item?
Absolutely, there has to be.
But I think we just want to finish this up, and I'm looking for a motion in a second. I think.
Well, Mr. Chair, if I may, I think you should let him speak.
You want to speak to this item?
Yes.
Okay. Name?
Again, I don't
Name
have...
for the record, please.
Libby Seifel. Again, I don't have the latest information, but according to the State Controller's report of 0910, the agency received approximately $40 million in tax increment and about $5 million in other revenues. The total of the two ROPS that you approved, I think, is closer to $80 million and change. So there is likely going to need to be something that's going to have to come off the ROPS, or you're going to have a challenge, a financial challenge. Again, you're so much closer to this than I am, but I just would like to point that out so that you know that this item actually could be important.
Thank you.
But my understanding was that what we approved was the actual tax increments that have already been set aside for the SA, right? We're not overreaching over and above what the tax obligations are we?
No, it was a 6 months ROPS.
Right.
For that 6-month period.
And I think at the same time, in approving the budget, with respect to what we have, you saw the decrease, thereby lowering what we have in the way.
No, I mean, my understanding, what I just heard was that the 1 year that we just approved is about $80 million. Is that what you said?
Yes, the total of ROPS 1 and ROPS 2, I believe, is about $80 million. I'm looking at the finance director to say if I'm correct.
Is about from that is 40.
Is about 40. I mean, I don't know what the estimate is for this year. I can only tell you what's been published for 0910.
Do you know what the estimate is for this year?
No, we don't.
So either it has to come from, some other source, like other revenues, which was theoretically $5 million in 910, or, there has to be cash reserves that it comes from, or something will have to be renegotiated.
See, this is not, I'm very exhausted because I don't understand how we can approve. I approved it based on an understanding that there's a tax revenue coming in for 12 months that now we're deciding where it goes. I'm hoping that we didn't just go 40 million over what we can actually collect.
I believe we did, and
maybe somebody could explain that.
You have to understand our frustration in trying to predict how much money we're going to get from the county. There's items that we are used to paying every year now that the county is going to be handling. So, you go and you deduct those items. There's items...
I'm even much simpler. The total number that we used to have, let's say, last year, the total number of revenues, tax revenues that we used to have, that's what if we have 80 and 40, I'm just...
Here's a quick clarifying question. Do your numbers match her numbers?
They do, but we also have bond proceeds, and so that's above and beyond the 40.
And how much are the bond proceeds?
We issued 2 bonds in 2010 and 11, and total is over $75 million.
And at this point, there is, my understanding, about $30 million in tax increment cash that was moved to the city's general fund.
To pay back.
To pay back the loan that had been incurred over the last 30 years.
Correct.
So there's $30 million sitting there in tax increment. There is another how much in bonded in debt, cash from bonds?
I don't have maybe
Bob,
somebody from finance.
Currently, I believe there's about 60, almost 70 million.
About $70 million?
60 million, excuse me.
So
unspent proceeds from the 2010 and 2011 issues. The 2010 was non-taxable to 2011 was a taxable issue.
Under AB 26 and 27, in a strict reading of that legislation, what happens to certainly to the tax increment, that $30 million of Glendale money, where does that go? Under 26, 27. That gets swept, does it not?
The trust fund, correct?
Well, I'm sorry, doesn't it, it's a repayment of a loan.
If I say it in the strictest interpretation of what 26 and 27 would be, which is hostile to the interests of Glendale.
Which is, I think, hostile to the interest of the loan.
Well, certainly, right? So that money, that goes away. There are cash resources that were part of a larger financial plan for Glendale that basically are in jeopardy. We're seeing pieces of that. The county's looking at pieces of that, and certainly the state of California is looking at pieces.
You're a whole lot more complex than my question probably was. My question is, if we have $40 million as a budget, as the tax increment coming in, and for the next 12 months we're going to do ROPS 1 and 2, and it says $80 million, where do we get the other $40 million? That's my question.
Mr. Chair, Mr. Garcia, I understand that you can advise me because I'm from the jurisdiction which employs you, perhaps not the others, but maybe it's advice. What we approved were obligations that the successor agency has. We're not in a position to say there's money to pay it or there's not. We're confirming that these obligations exist. And that's what we did with the approval of this.
That's correct. And then to the extent there are resources, both tax increment and other available resources that the agency had prior to dissolution, those could be used to pay those obligations.
To Mr. Abkarian's very specific question, in terms of the resources, there is cash from tax increment, there's cash from bonded indebtedness, and then there is the ongoing...
I don't want to go into it. All I want to know is that the staff would tell me there's enough money from whatever resources to pay the obligation of ROPS 1 and 2. Yes?
Yes. To answer Ms. Libby's question...
The short answer is yes.
Just yes?
Yeah, I just wanted to point out there's other sources of payment listed on the ROPS, such as bond proceeds for items number 29 and 35.
As I said, that's all I wanted to know. From the beginning, I just said, there's $80 million, there's $40 million. Is there enough cash to pay for these things? And your answer is yes.
Yes.
That's it. Okay. Thank you so much.
With that...
Sorry, but I don't want to make it confusing. I just want to...
I'm still looking for the...
I'll move 4G.
I second.
Any further discussion? Roll call, please.
Board members Abkarian.
Yes.
Lansifin.
Aye.
Nakasone.
Yes.
Ochoa.
Aye.
Sheehan.
Aye.
Steger.
Aye.
Chair Raggio.
Yes, and the motion passes. This is the time for oral communications. I have no other cards. Is there anyone?
We already did that.
We moved it to the front of the agenda.
Oh, all right. Then we're through.
So
Any comments from the board or staff?
I do. Mr. Chair, this has been a difficult meeting for me because I have not been involved in redevelopment, and so I sort of come at a disadvantage. And so the next time that we come, it's going to be really important that we have a lot more information. And it doesn't need to be, extremely detailed. It could be, summaries of what the major topics are, an indication that there is some money to pay for these obligations. I think we have to look at. I would appreciate people looking at me and saying he doesn't really, he doesn't, live and breathe this stuff. So I need information that is much more detailed and complete.
That's understood, and my comment to that is that this is a first for all of us. And I mean a first in that none of us have ever been party to an oversight committee such as this. The difficulty associated with it, as I see it, is that the legislation isn't clear enough for us to really operate, for one thing, and it isn't completed. The legislation is still in the making. So you're going to get smacked on either side of the cheek again, because when we get new legislation, the effect is that you go back to ground zero and start all over again. So I've been... I want to thank everybody on the board here because one of your patients, and that's in the audience too, in dealing with so many unknowns and trying to make something out of it. But I think that there are more unknowns coming than knowns before we get through with this.
I can appreciate that. And this was the big push, but now we have some time.
Yeah.
Now we have some time.
Perhaps Mr. Steger would benefit from attending or reviewing the training provided by LA County, which I believe Ms. Libby's group had a large part in. The county reps were invited to attend that training. There were 2 training sessions held and 2 webinars, and staff, Successor Agency staff, took the initiative to invite the other non-county representatives to also participate in that. But given that you joined us late, we'll make sure to forward that to you.
Yeah, and I actually did listen to the and watch the video last night till about midnight. But still, I think that if we could, for the next time that we do this, if there is more information, I think what the statute really basically says, it provides it's a floor, it's not a ceiling for information, and so I would be much more comfortable with more information on these items.
Noted.
Mr. Chair, just one last question. I think a few of the members asked that our rules include correspondence to everybody. Do we need to amend the rules that we adopted, or is it just noted?
They were in draft form.
Well, but if you want them actually included in the formal documents, it probably wouldn't be a bad idea to call that up.
It should just be noted.
We'll note it.
Note that do that it should be done as a matter of courtesy to everyone.
And we'll do that and make sure
that's a good idea, and it should be noted.
Okay.
Yeah, we all want to work from the same spot. Any further business? You move to adjourn?
Yes, sir.
We are adjourned. Thank everybody.